Good afternoon. It is McDonald's, but it's an iced tea. So, no calories. Yay, because I'm fat. CJ thinks I'm fat. I'm going to cry. I don't think I've insulted CJ so far. Anyway, he came into my comments the other day, and he said that he was going to drive viewers my way because I'm a small channel, and I've been on YouTube for 11 years, and I have less than 3,000 subscribers, and I'm not as cool and awesome as CJ is. And the net effect is that all of the CJ Grisham videos I've ever made have gotten very low viewers. I know it's weird. Every time I do a video on like Earl or Chili DeCastro or James Freeman, people are like, oh, you're just trying to ride their coattails. You're just trying to get clicks and views off it. But no one ever says the opposite when I make videos on people like, what's that Sobsit's name? Like Two Truth for Liberty? Like, you don't even know who he is. I made videos on him. I made like 3 or 4 videos on him because he's a fucking idiot. And he's in my comment section all the time being an idiot. But nobody's like, oh, you're really chasing clout going after him. And making videos on CJ Grisham obviously get me nowhere. But that's fine. I don't monetize my videos. I don't beg for money on my videos. I think I have a G-string account link, but all it is a picture of a dude wearing a really whack bathing suit. Anyway, did I show my age by saying whack? I don't know. Are the kids still saying whack? I don't know. What do they say? No cap, for real. It's bussin'. I'm too old. Anyway. But I don't do this. I don't do this for clicks or views, and I don't do this to make money. Unlike some people, I don't do it for that. I do it to educate you. I do it even when it's unpopular. I do it to give you possibly the tools you need to make better decisions. Now, I may not always be right, but I'm righter than someone who isn't an attorney. How about that? Generally speaking, I'm going to be more correct on the law than a non-attorney, and you could get an idea, at least, of how attorneys are going to react and how judges, because judges are attorneys, might react by my reactions and how I go about analyzing things. Even if you disagree with my analysis, you can see, because I show it to you. I show you the process of my analysis. This is how I come to the decision that X, like that a library is a non-public forum, or at best a limited public forum. Here's how I get there, right? And I show you the process. I don't play hide the ball with you. Now, like I said, I have not insulted CJ Grisham so far. I have not said definitively anyway on anything. I have merely provided you with more tools to better make decisions. And I think at this point it's pretty clear that it would not be a good decision to throw money at him. Now, at least not for this particular instance. I mean, if you want to throw money at him to advocate for your Second Amendment rights, like in a non-legal fashion, I think your money would be better spent. But looking at CJ's engagement numbers on his videos, even with a substantially larger audience, I'm surprised that he's getting as low of a viewership as he's getting. In the hundreds, not in the thousands of views, which is not good, at least at the time I'm recording this. So anyway, why am I making this video today? Well, because I don't hide the ball. It kind of irritates me when people do hide the ball. Like, it would be fairly simple for CJ to say, look, I'm not an attorney. By the way, I have screenshots of him calling himself the lead attorney for the Self-Defense Fund and an associate attorney at the Paul W. Davis law firm, which is calling himself an attorney. Now, he could say, I'm not an attorney. I'm on a provisional kind of, not a license, but I'm provisionally allowed to practice under the supervision of an attorney, of a licensed practicing attorney. In this case, it'd be Paul W. Davies. And as long as that attorney's there, I can argue a motion. As long as that attorney signs off on paperwork, I can prepare a motion. But I can't do anything on my own because I'm not an attorney yet. I am a I'm a graduated an eligible law school graduate who is currently in a provisional program to allow me to do things like practice law. Another thing that I can't do is I can't have my own clients, and I can't engage in like a fee agreement with a client. I can get paid by Paul W. Davis, but I can't get my own clients or have clients pay me. He could say that, but he doesn't. He wants to play hide the ball. He could explain to us how he thinks he's going to get around judicial immunity. I mean, if he has a way, and he says he has a way, then why not just say it? Why do we have to trust the plan? I mean, we've heard Q talking about trust the plan forever, and it's not working, buddy. It's not working. Every time these people, like, who's that? What's that gal? Sydney something. She was an attorney, and she was like, we've got the whale of a, what'd she call it? It was some sort of like a Kraken. The Kraken is coming or whatever. Like all of this shit. Every time anyone tells you that you got to just trust me on it, I'll show you later. Earl with his flash drive, you got to trust me. My attorneys talking to the Justice Department. You got to just trust me on this one. Every time it all turns out to be bullshit. Every time. And now what's CJ Grisham doing? Oh, you got to trust me. You got to trust me that I have a good plan for doing it after November. It has nothing to do with elections. I just got to do it from November. Oh, you mean after you get the bar exam results back and see whether or not you're actually going to get licensed to practice? Is that what you're waiting for, CJ? Is it? Why hide the ball, bro? Why hide the ball? If you think you can get past judicial immunity, if you think you can sue, let me be very specific on this. I believe that you probably can sue a judge as essentially a figurehead for like a rule of court that you think is unconstitutional. You probably could sue a judge, but that would be like a petition for habeas corpus where you sue the warden, right? The warden is the respondent. You're not really suing him, but you got to name a defendant. So there might be a situation where you can name a judge as a defendant, but only for the purpose of declaratory relief, like to have a particular rule of court or law, some sort of a law that judge would be responsible for, like a rule of court is what I'm thinking, but maybe there's something else, but something like that where a federal court can say, oh, I'm giving you declaratory relief that yes, that is an unconstitutional law or rule, not ruling, but law or rule. I haven't seen any case where you can sue a judge in his individual capacity, not as a representative of the judges, but as the judge, where you could get any monetary or injunctive relief, i.e. sue the court, sue the judge to have the judge set aside his motion. That is literally what a petition for a writ of mandate is for. That's literally what that's for. For the appeals court to tell the lower court what to do. Set this aside. But anyway, if you have a way around that, don't play hide the ball. We don't know who the judge is. We don't know who the client is. There's no need for secrecy. Just give us your plan. Just give us your plan. If you have it, share it. The only people I've seen ever suing the judge ever have been sovereign citizens. And they've never been successful that I'm aware of. And if you have a case, show it to me. I'd love to see it. But they've never been successful. Why? Judicial immunity. The Supreme Court has ruled on judicial immunity. It exists. It's a thing. It's gotta be a thing. And you can't get a higher court than the Supreme Court. I don't know how you're going to go around this. Don't play hide the ball. Don't play hide the ball. So I would like to challenge you, CJ Grisham, to a debate. Show me your evidence. We could have a neutral attorney like Juan Galt, or pick the attorney of your choice who's willing to moderate it. We'll even let Paul W. Davies moderate it. Now, speaking of Paul W. Davies, he would have had to have been there at the motion hearing where you filed the motion to get the gun back. And Paul W. Davis is not. I mean, that's Paul's client. It's not your client, Mr. Grisham, sir. It's Paul's client. And Paul's not filing an appeal. Think about that. Why isn't Paul filing an appeal, Mr. Grisham? I would posit to you that Paul, being a licensed practicing attorney with his license on the line at this point, and with a decent grasp, whatever you may think of him politically, he is an attorney licensed to practice law in the state of Texas. He is an attorney in good standing in the state of Texas. Whatever your differences with his political beliefs are, and I don't care about his political beliefs, so don't tell me in the comment section that he has some wackadoodle political beliefs. I literally don't care. But if he's not doing it, there's probably a reason. And that reason is probably he doesn't want to jeopardize his license by filing a frivolous lawsuit or a frivolous appeal. Because I bet I'm not licensed to practice law in Texas. I'm not giving you advice on how to practice law in Texas, but I would bet that if you look in the statute somewhere, there is some sort of sanction that the court or the Court of Appeals can impose upon you for filing a frivolous appeal. I would bet that. I'd bet you a shiny brand new nickel. But anyway, debate me, bro. Debate me, CJ. Esquire. If you think you can get past judicial immunity, debate me. You play petitioner or plaintiff. I'll play defendant, and we'll see whatever judge we pick, who I would like to be an attorney. I'm just saying that, like Juan Galt. I'm going to nominate Juan Galt. He hasn't agreed to do it yet, but I bet he would because he's retired. Or any other attorney like I said, even Paul W. Davies, as long as it's a licensed practicing attorney, let's see who's right and who's wrong. I mean, put up or shut up, son. Thanks for watching. Have a great day.